Thank you, Larissa. I asked for short and sweet. She certainly accomplished sweet. But that was a very generous introduction, and I really appreciate it. I can't tell you what a pleasure it is just to be here today. All these people in person is fantastic, and I want to thank every one of you who has come because of the contribution it represents to doing better with our profession. And I also want to disclaim the title of a founder of UCLI. I was a founding board member, but the truth is that Kristen Olson, whom you've heard from today, and Melinda Bowen, is Melinda here? I haven't seen her. Okay. They are the founders of UCLI. As two young lawyers, and in fact, I think one of you was still not a graduate, is that right? Just barely out, okay. They came up with this idea. They looked around at the profession they were joining and they said, there's got to be a way to do better. There's got to be a way that lawyers can think harder about solving the gaps in our profession in connection with diversity and inclusion. And by the time they got to me, they had already mapped out how they wanted to start, and they've been doing the work. They were doing the work then, and they've been doing the work since. And I'm so grateful for the opportunity to work with them and to follow their enthusiasm and commitment to these issues. I'm having a really interesting experience right now. I've been reading a fairly new book. Actually, I think some of the research goes back a year or two, but it's called Shortlisted: Women in the Shadows of the Supreme Court. This book documents the experience of women in the legal profession through the lens of the appointment process for the United States Supreme Court appointments, going back to the early and mid-20th century. It's a fascinating piece of research, and if any of you are interested in that particular history or interested in the Supreme Court, the inside view of what's going on in the president's offices and the presidential debtors' offices, and the letters and tapes of phone calls that, or overheard comments that are still extant. I mean, it's mind-blowing. The work reveals a profoundly moving set of data. Presidents from Roosevelt to Clinton used the shortlist for the United States Supreme Court as a parking place for a long list of extraordinarily qualified women who had no chance of being appointed. So they got credit both for caring about diversity and inclusion, but it didn't have to do anything about it. Okay, that's one of my points. In 1971, that was the year I finished law school, the New York Times, my father-in-law used to really revere the New York Times, and he always said, if you can read it in the New York Times, it's got to be true. It was the only way that he was convinced that I was going to marry his son was that I put the announcement in the New York Times. I didn't think I'd do it. But the New York Times wrote this about Mildred Lilly from California, who was shortlisted by Richard Nixon for the U.S. Supreme Court. She was a phenomenally accomplished and revered California judge with a very, very good academic background. She had all the usual accoutrements. The New York Times said that Mildred Lilly, fortunately, that's a quote, has no children. The article then went on to marvel at how she maintained, quote, a bathing beauty figure in her 50s. Can you imagine? Okay. So that's the New York Times in 1971. So what I'd like to use that as a platform for talking about is the kinds of things we have to figure out to do instead of just to embrace as a aspirational matter. And certainly we've heard lots of things that UCLI and UCLI people and the law firms they're working with all over the state of Utah are doing. But there's some interesting data out there. Do any of you know what the Rooney Rule was? The Rooney Rule was named after somebody who was very important for some football team. I'm sorry, I should have written that down because I know nothing of sports. But Rooney was a very big deal, and he convinced the National Football League, the NFL, to adopt the Rooney Rule, which required them to interview at least one minority for every coaching or other important management position where they were hiring. Guess what happened? It did not integrate the coaching staff in the NFL because, again, the shortlisting phenomenon occurred. It gave lip service to diversity and inclusion without requiring anybody to do anything. And then I am informed that there in 2017, it was adopted out of a think tank effort, something called the Mansfield Rule. Anybody here heard of the Mansfield Rule? That's interesting because it purports to apply to law firms and corporate law offices. And it's a rule that when employers are hiring, they consider that their application lists contain at least 30% women and minorities. The fact that none of us even know about it suggests how much good that's done. Now it's only been around since 2017, so maybe we don't know how well it's working, but I urge you all to look up that. It's getting at the pipeline at a one-to-one level. Getting kids early in school and in middle school to know what lawyers do, to know how lawyers are problem solvers, to know how important the work of lawyers can be to the stability and success of our nation. 2 years ago, a couple of professors, they weren't lawyers, they were sociology, economics, public policy people from Harvard and Stanford. They convened a symposium with a bunch of experts on bias, on technology, on discrimination, and on organizational design. One of the things I've noticed over the last number of years is how far behind the legal profession has been compared to the business world. The business world, I think, started out thinking that there was a really strong business case for diversity and inclusion. There's been some pushback from the literature I've read from some people saying, the business case isn't the point. This is a moral and societal obligation. But in any case, for whatever reasons, business has been ahead of us. But at this symposium, it was just 2 years ago, they only addressed one question. In reducing the amount of bias and exclusion in the world, what works? Not how bad the stats are, but what has been shown to have potential for changing the stats. They've done a report, if anybody's interested in finding it, called What Works? Evidence-Based Ideas to Increase Diversity, Equity, and Inclusion in the Workplace. People can learn from our colleagues in the business world. And I just want to share quickly with you 5 insights from the particular, they called it I forget what they called it. It was sort of like, it wasn't a convention, it was a convening of all these experts to address this question. The first key insight as to what works is summarized as follows: collect, count, and compare. What do you collect? You collect your data. You find out what your numbers are. You find out, you identify what your goals are, and then you address your numbers in comparison to your goal. And you also include timelines. So if you sit down as a planner or a leader in your corporate or law firm setting, that's where you start, is finding out where you are, and then measuring how you're doing over time, relying on data, and most importantly, reviewing the amount of change over time, and then going back to the goal setting. Goal setting starts it, you move through, you evaluate, and then you go back to setting goals. I've often said when I've been at award settings and so on, that as humans, as a society, we tend to measure what we value, and I think that's in terms of what we honor, I think about in that setting. But I think the same principle applies in terms of changing our professional world. I think it matters what we count and what we look at and what we identify as important. So the second key insight was that we should use alternative complaint systems. And I found this really insightful, because what happens when somebody in your workplace is really unhappy or feels that they've been mistreated? Okay, so they either tell somebody or they don't tell somebody. When they tell somebody, what happens? What are they met with? And if they don't tell somebody, what happens and what are they met with? And there's plenty of research that shows that complaints about harassment and discrimination, approximately half of them, now this is statistics from the business world, I don't think it's very different in the legal world, but about half of them result in some kind of retaliation, plus career changes and impact on the complainant's mental and physical health. So telling someone doesn't work out so well for people, and it's because of the kinds of systems we've developed for helping people who are running into difficulties in their work setting. So we have all kinds of other ways that we've built into the profession now for solving disputes and difficulties. Why don't we think about using them within our own institutions in the law? Things like employee assistance plans, and some of these are good for big legal institutions, some are good for small, some aren't good for all of them. Creating, and I gather the new term is ombuds. You can't say ombudsmen anymore, you shouldn't anyway. Ombudswomen, but that's a mouthful. So creating ombuds offices or persons within your outfit, setting up mediation and alternative dispute resolution processes for helping somebody address what appears to be a glitch in the workplace relationships. Now, if you're going to do this kind of thing, it really requires a shift in the mentality of leadership. You've got to really change the mindsets from seeing every complaint as a threat to valuing complaints as a way to generate positive organizational change where it's required. That's a big shift, and especially a big shift for lawyers and for managing lawyers, people who are running outfits with lots of other lawyers in them. The third insight that came out of this work was that you need to test for biased technology and other data. They were particularly talking about the degree to which apparently a lot of business entities use algorithms and technological data to do things like screening and hiring and firing and so on. So that's one problem, but I think it's more extensive than that. I don't think it's just the technological data and what's built in to the algorithms. I think it's the degree of unexamined, unknown predispositions that we all have as human beings. We don't even know sometimes when we're stereotyping people or gauging our expectations to what we know about them that may or may not be relevant. So you've got to make sure that the data you're relying on in screening, in hiring, and firing, and evaluation is huge. They need to be based on fair, equitable data, including assumptions. I once was recruited by the then bar president here in Utah to gather a group of hiring and evaluation attorneys from all the big firms in Salt Lake. This was a long time ago. But I sat across the table. The only two women in the room were the bar president and me. I was on the court, so that helped. But one of the lawyers at one of the big firms, we had a pretty free-flowing conversation. A lot of them were actually surprisingly defensive. And he pushed back. We were talking about work schedules and some of the needs that, for example, young women who are being hired for law firms have in terms of family responsibilities, and that young men might someday acknowledge that they have in terms of family responsibilities. And he looked across the table at me and he said, I just flat out will never be convinced that that anyone can become a decent lawyer by working part-time. Now, he did not know the portion of my career as a lawyer, which had been part-time. So he didn't realize that he a judge and think part-time bad lawyer, for which I'm grateful. But again, that's assumptions and expectations that are going to be used across the board. You wouldn't want to ask for family leave at his firm. Anyway, no matter who you are, but especially if you're a woman who's expected to do that. So number 4, behavioral scientists and others who've been engaged in this research agree that when individuals belong to groups with serious underrepresentation, and we've heard some of the voices that have spoken today about the feelings of isolation that come from being the only one who looks like you or sounds like you or has a background like yours, to be in a legal setting, whether it's law school, law firm, your first employment. I really like the comment about not knowing the do's and don'ts of law firm interviews when you're getting out of law school. I didn't have to worry about that because when I was at Duke University and graduated in the early 70s, none of the major law firms from New York, Atlanta, Washington would even interview women. They specified that they would interview law review participants who were men. That was it. So I didn't ever have to figure that out. Still don't know what you're supposed to say. So when you're only one, the threat or the risk of tokenism and stereotype-based evaluations is very real. And the pushback from these scientists is that you've got to give people the wherewithal not to be intimidated by the numbers. And employers can contribute to that when there are very low numbers. Promote the people in those categories. Give them visibility, give them opportunities to shine. Make sure that work assignments are fair and equitable. And that, of course, doesn't obviate the need to, at the same time, be trying to up the numbers and increase the size of the group. But because of my age, I've been the only woman in the room. I was the only woman in the room for a long time in almost every setting. And I think any successful lawyer has to acknowledge having had help in moving up in the profession. People who show them the way, who answer their questions, who warn them about mistakes they might make. So these are mentors and coworkers and people in their personal and professional lives who give advice, mentoring, and chances to shine. I just want to mention here one of my huge mentors. I had a number. They were all men, because there weren't any women. Enough ahead of me in my circle that helped. But the first senior lawyer I worked with in Salt Lake City was a man named Norman S. Johnson. I don't think anybody else here is old enough to remember. Oh, good, Anne, thank you. Norm was an extraordinary man. He worked for the SEC and he set up his own securities law firm in Utah. And when I moved here from North Carolina, a friend of mine who was already at his firm told me they were looking for a lawyer to do litigation. And so I said, well, I need part-time. I was just having my third baby. I think it was my third. Might have been my fourth. Don't remember. And I said, well, I need part-time. And he said, I don't think that'll be a problem for him. So I came and interviewed with him. It was a very small firm. It was just him and 3 partners and my friend who was an associate. So, and he didn't even ask me about the babies or the part-time. And he also didn't ask me if I'd ever studied securities law, which as it turned out, I hadn't. And he hired me. He hired me part-time, and he taught me securities law, and he taught me how to teach myself securities law, and he mentored me in the litigation process. I remember going to court one day in the 3rd District, and one of the lawyers from the other side came over and looked at me and him and said, wow, you're really coming up in the world, Norm. You get to bring your secretary to the trial? And he said, she's not my secretary, she's my partner, which of course was a bunch of hooey. But he wanted to give me an opportunity not to be dissed by another lawyer. So now get leaders and management people on board from the start. In other words, you've got to get people in the institution, no matter how large or small, to own it and be willing to help you build it. And I think that's another area in which UCLI has done a fantastic job of giving lawyers ways to sell some of these ideas and giving people help to create buy-in around the profession. And I just have to say, speaking of buy-in, it is fantastic to see all these people who are here to support the work and the mission of this organization. And it's also wonderful to see the amount of financial support that has come into UCLI over the few years it's been in existence in order to do the programs that you saw highlighted in today's comments. It's very important. I mean, I'm going to make a donation today because I've been off the board almost a year and I haven't made one in the last year, and I need to do that. And I hope anyone else who is so inclined to support the wonderful work, and sometimes it's volunteer work too. I mean, there are a lot of people who can't make large donations who are still giving their time, which is hugely valuable, and we thank them for it. I'd like to close with the comment of one of the sociologists who did this 5-step summary of that symposium, because it's very moving, and frankly, I couldn't say it better myself. He wrote, this is part of, he was talking about the pushback against the business case for diversity and inclusion. He says, well, it's fine, and if that convinces people that they'll make more money if they do right by diversity and inclusion, fine, but he said that shouldn't be the point. That should not be the point. And asks, why should anyone need an economic rationale for affirming the agency and dignity of any group of human beings? We should make the necessary investment because doing so honors our own and others' humanity and gives our lives meaning. If company profits, and I substitute law practice profits, come at the price of our humanity, they are costing us too much. And if diversity initiatives fail to reckon with that trade-off, they will amount to little more than rearranging the deck chairs on a sinking ship. Thank you very much.